Now, Mr. Bailey, would you like to resume?
Can I pick up very quickly two short points that arose out of this morning? Firstly, in answer to Lord Leggett's question, I perhaps also have referred you to page 810 of the bundle, which is page 607 of Lord Diplock's speech in Tunisian. But in my submission, it's perfectly clear reading that and the whole of the judgment that when he was referring to stage 1, he was including the first 2 limbs of the common law test, and stage 2 was the third limb. And secondly, my lords, in answer to Lord Burrow's question this morning, I've been reminded, quite rightly of course, that the difficulty in having a default rule that the proper law of the arbitration agreement is the law of the seat doesn't and can't operate as a universal rule, precisely because the absence of a seat or the absence of a curial law doesn't prevent the formation of an arbitration agreement, and therefore one could easily have circumstances where there is no choice of seat in a contract at the outset, and therefore those cases couldn't be dealt with on that basis. Now, my lords, if I can go back to where I was, and I apologise for labouring it, but Hamlin and Tunisienne are 2 of the key cases that my learned friends rely upon. And I was on my 5th of 6 points on Tunisienne, I think just before I lost Lord Hamlin. And that was that the usefulness of Tunisienne is that it explains the basis for the implication of a choice of proper law from an arbitration agreement as being the fact that one would anticipate that the arbitrators would be applying their own substantive law to the dispute between the parties. My point then is this, that rationale doesn't apply. Indeed, the reasoning breaks down in circumstances such as here, where it's common ground that the law to be applied by the arbitrators to the substantive dispute between the parties is Russian law. The 6th and most important point I have on Tunisienne is this, that it is not authority for the proposition that an express choice of seat carries with it an implied choice of proper law. And to make that point good, can I take your lordships to a case called the Star Texas, which is at page 4418 of the electronic bundle.
Yes.
And it's a decision of the Court of Appeal, and it's 2 parts of Lord Justice Staines' decision, which I'd like to take your lordships to briefly, if I may. Just to set the scene, this case was about an arbitration clause which provided for effectively a floating choice of seat. And what was being said by Mr. Ricks, as he then was, well, if you have a floating choice of seat and they both imply a floating choice of law, the arbitration clause must be invalid because you cannot have a floating choice of law. That was the argument that Mr. Ricks thought up and was arguing in the Court of Appeal. And one sees the way it's dealt with by Lord Justice Staines, he then was, at page 4424 on the left-hand side. And this is, if I may say so, important and significant. So I just, if I can ask you, lordships, kindly to look at it on the actual page, rather than just giving the reference. The key points I want to emphasize are threefold. Firstly, on page 451 on the left-hand column, Lord Justice Staines says, the question is therefore a narrow one. Is the arbitration clause in the Charter Party governed by an ascertainable proper law? That's the way he articulates the question. Then halfway down that column, he says, Mr. Ricks's argument concentrates entirely on the terms of the arbitration clause, and he relies upon Tunisienne, and then this sentence is important. He seeks to extract from this case the proposition that an express choice of forum amounts to implied choice of applicable law in the absence of overwhelming rebutting factors. I would not accept this interpretation. On my reading of Tunisienne, its authority for no more than the proposition that a choice of forum will generally be a strong but not necessarily decisive factor in relation to the issue with which legal system the contract has its closest connection. And then he goes on to refer to an article. And then at the bottom of page 4424 on the right-hand column, he says, the principle which is expressed there in Latin, but which means an express choice of forum is an implied choice of proper law. So we're using English, of course. He says that principle forms no part of our law, meaning English law. It's clear from Tunisienne that even an express choice of jurisdiction does not by itself give rise to an implied choice of law. It may do, and this is important, and if I may say so, it chimes with what we'll see Lord Hamlin said later in a case called Habas. It may do so together with other factors, but more realistically, it will play an important role in the next inquiry, that is the determination of the system of law with which the contract has the closest connection. Given that the actual selection of a place of arbitration does not of itself give rise to an implied choice of law, it seems to be implausible to suggest that the granting of an option to choose the place of arbitration can by itself give rise to an implied choice of floating applicable law. Now, my lord, that case is very helpful because what it demonstrates is that although Tunisienne contemplates that an arbitration clause, particularly one that provides, for example, for LMA arbitrators or arbitrators from a particular body or so on, may amount to a choice of law, the mere choice of a forum, the mere choice of seat by itself does not carry with it an implied choice of law. So what we would respectfully submit is that against that background, the Court of Appeal was wrong to regard Tunisienne and Hamlin as authority for the proposition that a choice of seat carries with it any form of choice of law. Other factors will be required in order to reach that conclusion. Now, against the background of Tunisienne and Hamlin, a whole body of jurisprudence built up between 1971 and 2000, basically following what we've described in our written case as the orthodox presumption. The Court of Appeal largely glosses over those cases. They're in our written case, and I'm not proposing to take your lordships to them, but obviously they're all important. There is, however, one of those cases which is sufficiently important that I'd ask if you may to turn it up, and it's a case called Black-Clawson. It's a decision of Mr. Justice Mustell, as he then was, and the reason why it's significant is because in my submission, it's the proper understanding of this case which explains how the law went awry in 2000 and thereafter for a short while until South America. Because decisions like XL and Owens Corning and decisions like C versus D are, in my respectful submission, based upon a misinterpretation of what Mr. Justice Mustell said in Black-Clawson. And that's why it's important. And as I say, it's in bundle E4 at page 689 of the electronic bundle. Taking this as quickly as I can, I can point you to a particular dictum that's caused the confusion. It's to be found on page 696 of the electronic bundle. And it's in the left-hand column, where Mr. Justice Mustell, as he then was, says, as regard the second question, it has, I believe, been generally accepted that in an arbitration case with a foreign element, three systems of law are potentially relevant. Number one, the law governing the substantive contract. Two, the law governing the agreement to arbitrate. Three, the law of the place where the reference is conducted, the lex fori, or the curial law, as it may be called. And then he says, in the great majority of cases, these three laws will be the same, but this will not always be so. It is by no means uncommon for the proper law of the substantive contract to be different from the lex fori. And it does happen, although much more rarely, that the law governing the arbitration agreement is also different from the lex fori. Now, it's that dictum and its proper interpretation which has given rise, we would submit, to the flaw in both XL and C and D. Because on the face of it, read in isolation, it could easily be thought that what Mr. Justice Mustell is saying is that the law of the arbitration agreement will usually follow the law of the seat. And that, in my submission, is actually not the correct understanding of that dictum. And what I'd ask you to bear in mind, it may seem pernickety, but it's significant as when we look at the later reasoning in this case, is in the first part of the dictum where he divides up the three laws, he uses the phrase, the agreement to arbitrate. Whereas in the second part of the dictum, he talks about the arbitration agreement. Now that distinction is important because, as we'll see when we look at this case, and I'll just point out the relevant parts, perhaps not read them, is that what what Mr. Justice Mustall ended up doing was recognizing the fact that the context of an arbitration agreement gives rise to two separate sets of contractual obligations, which are what he describes as being the continuing or continuous agreement to arbitrate, which is contained in the contract, and then an individual arbitration agreement that arises when you refer a dispute to arbitration. And that's clear from page 455 in the right-hand column, where he says at the top, having analysed the fact from Bremer Vulcan that these two sets of different contractual obligations arise, he says, 455, page 698, if this analysis proves correct, so that the individual contract to refer has a life which is independent of, though springing from the original agreement to arbitrate future disputes, it must follow, at least in theory, the two sets of contractual relations may be governed by different laws. It may be objected that this piles up the proper law absurdity high. We already have the substantive proper law and the lex fori. To these we must now add the proper law of the continuous agreement and the proper law of the individual contract to refer. So now he's identifying four potential systems of law. And this is essentially the foundation of what's become known as the doctrine of double separability, which is referred to and discussed in the textbooks, and also in cases like, well, in particular, I was thinking of Mr. Justice Potter, but in a number of cases, Arsenovia is another one, that there are these four categories of systems of law applicable to an arbitration agreement. But the key point really is in the next part of what Mr. Justice Mustall says. He says, in practice, this objection is unlikely ever to arise. In the great majority of cases, the same law governs all aspects of the matter. When the laws diverge at all, one will find in most instances that the law governing the continuous agreement is the same as the substantive law of the contract in which it is embodied, and that the law of the reference is the same as the law of the lex fori. So in other words, he's there saying correctly in my submission, and consistently with what he says in his book and what he says later in Channel Tunnel, is that the continuous agreement to arbitrate, in other words, what we call the arbitration agreement contained within, embodied within the matrix or the main contract, usually, normally, it's of course dependent upon the circumstances, but normally will be the same as the substantive proper law of the main contract. And likewise, he makes a similar point at page 456 of the report, page 699 of the electronic bundle, in the left-hand column, the first new paragraph. In these circumstances, it is unnecessary to reach a conclusion as to the proper law of the continuous agreement, that is the agreement within the context of the actual arbitration agreement embedded in the main contract. And he says, in the ordinary way, this would be likely to follow the law of the substantive contract. So what I'm basically submitting is that Black-Clawson, properly understood, is actually authority for the same proposition that Lord Mustall makes in his book and in Channel Tunnel, that ordinarily the proper law of an arbitration agreement will be the same as the proper law of the matrix or main contract within which it is contained. And it was a misunderstanding, if I may say so, of that earlier dictum read in isolation, that in my submission is the key to understanding where the law began to go wrong, as it did in our respectful submission in 2000 in the case of XL and Owings Corning. And again, we would submit in C versus D. XL and Owings Corning is a decision, it's in the same decision of Mr. Justice Toulson as he then was. It was a case on the Bermuda form. It's at page 1198. And what our submission is, basically, there are three fundamental errors in that decision. The first of which is that he misunderstood Lord Mustall's judgments in both Channel Tunnel and in Black-Clawson, and as a consequence he proceeded on the false premise that what Lord Mustall was saying was that the proper law of the arbitration agreement contained within the substantive contract would usually be the same as the curial law of the seat. That was a misunderstanding of Black-Clawson, and that's what led, if I may say so, to the fundamental errors that follow. Secondly, in search for justification for that mistaken view of what Lord Mustall had said, he sought to suggest this was because the curial law overlaps with the substantive law and controls such as meaning and scope and validity. Now, my lords, that is, we would submit, a further error for reasons that my learned friend Mr. Landau will explain later this afternoon. And final error, my lord, is that he relied, we would submit, on the doctrine of separability to justify depassage by implication. And in respectful submission, there was no justification for that, although, as the judge rightly observed, his decision on that point was in any event. Now, the next case is C versus D, where we would submit the similar errors were made. The discussion of the proper law issue is in the judgment of Lord Justice Longmore. So page 733, I beg your pardon, 733 of the electronic bundle, page 10 of the internal pagination of the case. And the first point to note is that, as Lord Justice Longmore correctly noted, this part of the decision was actually purely obituary. It wasn't necessary for the main reason why the case was decided the way it was. But the relevant part of the case dealing with the proper law of the arbitration agreement runs from paragraphs 21 through to 29. And in our submission, there are at least three errors in this case, which are very significant. Firstly, in paragraph 22 at page 733, the judge appeared to move straight from the first limb of the common law test to the third limb. And this picks up on a point that Lord Leggatt and I were discussing earlier. In other words, he overlooked that it was necessary also to consider whether the parties had made an implied or inferred proper law choice. Secondly, in paragraph 23, we will see, in my respectful submission, that he has misunderstood the Tunisian case. As is clear from that case, the House of Lords, in fact, approved and applied a three-limb test, of which perhaps the first two limbs are part of stage one and the third limb part of stage two, but a three-limb common law test, which is relevant to the inquiry, and it's not restricted to the closest connection test. The correct approach is to ask the question whether the choice of law for the main contract extends to the arbitration agreement either expressly or by inference. And then the third error, with respect, my lords, is that it's clear from paragraphs 24 to 26 of Lord Justice Longmore's judgment that he misunderstood the dictum in Black Clawson. And the correct analysis is that of Black Clawson is that which Lord Justice Morbick explained in the Sul America case, which is the next of the main cases on this topic I want to take you to. It's also in that bundle at tab 23, page 1130 of the electronic bundle. And it begins, as you will have seen, in paragraph 11 with what he regards as the proper starting point, and that is essentially the presumption that is referred to in Win Peel's article or note that we saw this morning, and that is that it's probably fair to start from, this is at page 1137 of the electronic bundle, between B and C. It's probably fair to start from the assumption that in the absence of any indication to the contrary, the parties intended the whole of their relationship to be governed by the same system of law. And having set out that assumption, he then justifies it, in my submission, entirely correctly, by properly analysing both Channel Tunnel, where Lord Mustall made a dictum that's there set out between D and F, and perhaps more significantly, what he says about Black Clawson, paragraph 12, at the bottom of page 1137. And he returns to Black Clawson at paragraph 22 and 23. And in my respectful submission, Lord Justice Morbick correctly and properly exposed the fallacy in XL and C and D, in that they both proceeded on a mistaken understanding Black Clawson. Also significant, my lords, is paragraph 26, where he deals with the relevance of the indivisibility arguments and the separability arguments. And the point that Lord Justice Morbick makes is, although there is a concept of separability, it's not one that's applicable in the context of a conflict of laws inquiry. And this essentially, again, I mean, you'll be able to read his paragraph 26, page 1142, between E and H. And it's an analysis which is reflected elsewhere in authorities, most notably BCY, which we'll look at, which is Singapore decision, which is in the bundles. It's also repeated in, interestingly enough, in Hamlin itself. And indeed, in my own friend's written case, they accept that there was a rejection by Lord Herschel of the separability principle as a basis for depassage. And in my respectful submission, this analysis, coupled with the fact that Section 7 of the Arbitration Act and the DAC report make it perfectly clear that separability is not a freestanding principle which applies universally, but in fact is a more limited principle of law that is based on a legal fiction, but an important one because what it serves to do is to protect the validity of the arbitration agreement in circumstances where the validity of the main contract is in jeopardy. That's why it's a very important concept, but it's limited in our respectful submission to that scenario and can't be usefully imported, for reasons that Professor Briggs has in our submission persuasively explained, into a conflict of laws context. Now, one point about Sulamerica is that in the ultimate analysis, the Court of Appeal concluded that the arbitration agreement was governed by English law, not Brazilian law. And the principal reason for that in our submission is the fact that the contract or the arbitration agreement would have been invalid as a matter of Brazilian law. And in my respectful submission, going back to some of the points I made this morning based on Lord McDermott and Lord Justice Bowen about the circumstances, the rare or exceptional circumstance when you can have depassage by implication. One of those circumstances is where validity of the arbitration agreement is in question. And I accept that. But what's important, my lord, is that the validation issue doesn't arise. My lord, Lord Sales.
Sorry, I have to wait to be unmuted. I appreciate that it's probably not going to be relevant in our case, but I have a little bit of a difficulty in understanding how the invalidity of, or potential invalidity of, the arbitration agreement feeds into the choice made by the parties. Because one might think that, well, you decide what choice they've made as to the law, and they then take whatever law they've decided, lock, stock, and barrel. And if it happens to be invalidity, which they almost ex hypothesize will not have anticipated, that's just a consequence of the choice that they've made. Can you help at all about how one somehow, it's almost as a second order of deciding their choice, if they'd appreciated, which they didn't, that choice of one law would mean that the contract was invalid, therefore they're to be presumed to have chosen the other law. Is there any explanation of how that works conceptually?
Well, my lord, if I can start by saying that the analysis your lordship has just propounded is intellectually unassailable, and it is the answer effectively that Lord Maclaren gave in the Hamlin case. In other words, he said they made their choice of Scottish law. It's unfortunate that as a result, but separability and depassage can't save the day. So they're stuck with their choice. And that's consistent with the analysis that my Lord Sales has just put forward. And indeed, is perhaps the most intellectually straightforward answer. But the reality is, as illustrated by the House of Lords decision in Hamlin, is that the courts have, perhaps for reasons motivated by questions of policy, perhaps, taken the view that when it appears that a clause is invalid by what prima facie may appear to be its proper law, and yet by a relevant competing proper law could be valid, then one is entitled, in a sense, after the event, to infer that the parties intended that the law which makes the contract or that particular provision valid was the law they must have chosen. But my lord, it is an exercise, intellectually at least, which involves an element of reverse engineering.
Thank you. Thank you.
But my lord, on validity, can I make this this short point, which is this: that you may have seen in my learned friend's written case at paragraph 68 that it's been suggested that the validation principle is actually engaged in this case. Now, the 3 points I want to make on that, and they're as follows. This is a new point that the respondents have taken, and moreover, it's a manifestly bad one. And there are 3 reasons for that. The first is that the point is not addressed in the judgments below, and the reason for that, the simple reason for that, is because it was common ground between the experts on Russian law at the trial that the arbitration agreement was valid as a matter of Russian law. The second point, and perhaps this is the most important and it's conclusive, is that Enka has misinterpreted my client's submissions in the Russian proceedings. And I can make that point demonstrated, make it demonstrably clear by actually showing you what the Russian court's judgments on Enka's stay application said. We have the judgment of the Russian court, I think, in 2 places. It's translated into English, but I can take you or give you the references to both. The first one is it's in the appendix, which is, I think, a different document, which I apologize if you need to open it on your screens. But if you're able to open the appendix, I believe it's at page 565 of the electronic appendix document. I seem to have got a bad reference there. Oh, sorry, 565, I beg your pardon. No, now I've got that wrong as well. I'm desperately sorry. I'm so sorry. It's page 716. So sorry. I beg your pardon, my lord. It's page 716 of the appendix. And this is an extract from the Moscow first instance decision, which dealt with both the merits and the application by Enka for a stay under Article 2.3 of the New York Convention to Arbitration. And what's important at page 716 is halfway down the page, the Russian court says no other agreement additional to the mentioned above has been entered into connected with the making changes to this agreement for disputes to be considered by an arbitral tribunal. That's a reference to the arbitration clause. And then they say this: the validity and feasibility of the agreement for disputes to be considered by an arbitral tribunal is not in dispute. In other words, it's common ground between the parties that there was no question of the arbitration agreement itself being invalid as a matter of Russian law. The only question was as to its scope when properly construed and whether or not the dispute fell within it. And that's there is a second translation. It's in the main core bundle at C168. I believe that's page 5457. So this is a translation of the extract from the Russian court's judgment dealing with the stay application. On page 5457 of the electronic bundle, nearly towards the end, is the paragraph beginning no supplemental agreements. And if you have that, but it's no supplemental agreements to the above mentioned, above said contract related to amendments to this agreement to consider disputes in the arbitral tribunal were concluded. And the claimant, that's Enka, sorry, that's my clients, the claimant did not challenge validity and enforceability of the agreement. So it's recorded expressly and explicitly that my clients were not contending that the agreement was invalid as a matter of Russian law, and that's hardly surprising because it plainly is valid as a matter of Russian law, as indeed the experts in this trial concluded. So the validity point simply is a red herring we would respectfully submit in this case. Going back to the authorities, the next decision, perhaps we don't need to look up, but it's an important one, is a decision called Arsenovia. It was a decision of Mr. Justice Andrew Smith, decided in 2013 after Sul America, and it considered both Sul America and C&D, which preceded it, recognizing, of course, that the two decisions were in fact irreconcilable. He followed Sul America, and as you will see from that case when you look at it, he concluded that the arbitration agreement was governed by Indian law, which was the substantive proper law of the main contract, rather than English law, notwithstanding the choice of a arbitral seat in London. The relevant parts, if you want to take a note, are page 667 to 674 of the electronic bundle. The next question, which perhaps we ought to look at, is a case called Habas, which was decided by my Lord Hamblin in 2014. And we have that in the B bundle, the main primary bundle of authorities, at tab 13, I believe. And what's significant about this case is that what Lord Hamblin did was, having read Sul America and Arsenovia, when you get to page 978 to 979 of the bundle, you'll see it between paragraphs 100 and 103. Lord Hamblin analyses the authorities, and in paragraph 101 there are 6 sub-paragraphs by which, as the learned judge, Mr. Justice Hamblin, as he then was, said, were a summary of the guidance provided by these authorities. And by reference to these authorities, he was providing guidance as to what was decided by Sul America and by Arsenovia. It's not a comprehensive account of every principle relevant to the context of ascertainment of the proper law of arbitration agreements, but a summary of what those 2 cases decide. And if I could ask you to pick up the following points. Firstly, in paragraph 99, and this is important, what you will see is that what follows from Lord Hamblin is on the basis of an assumption. And the assumption is that there was no choice of law for the matrix contract. In other words, this was a case where there was no express nor implied or clearly demonstrated within the meaning of Article 3 choice of law for the main contract at all. And that's very significant in my respectful submission, because it distinguishes what's said in Habas from the position here in this case, because our submission is there is an express or a clearly demonstrated choice of Russian law. So that assumption is very important. Secondly, the second point I'd ask you to note is on page 979 at the bottom of the left-hand column, page 102. And what Lord Hamblin says at 102 is, in relation to point 3, and that's the point about the arbitration clause can be overwhelming in the context of closest connection. He says, in relation to that, I would add that the terms of the arbitration clause may themselves connote an implied choice of law. It's recognized that they. Now, what's significant about this is that the learned judges quite accurately and precisely refer to the fact that it's the terms of the arbitration clause itself, not just the seat. It's the terms of the arbitration clause itself which may give rise to an implied choice of law. And that's highly significant, because that's wholly consistent with what's said in the Star Texas that we looked at this morning, that a mere choice of forum is not an implied choice of proper law. It's the fact there may be other factors from the clause itself, as we saw in Hamlin, as we saw in, or you will see in Egon, which we'll consider, which may give rise to that implication. And indeed, Lord Hamlin accurately refers both to Tunisienne and Egon as examples of where such an implication of a choice of proper law can be drawn from an arbitration clause, depending on its terms. And he makes the point quite rightly, in such cases they must surely equally operate as an implied choice of law for the arbitration agreement. And again, that is accurate and entirely chimes with the way it's dealt with in all the relevant cases, such as Tunisienne and Egon, where there was no suggestion of depassage at all. All those cases proceed on the basis that once a choice of proper law is identified, even from an arbitration agreement, that system of law is to apply to both the arbitration agreement and the main contract. And that's significant. Now, what my learned friends, however, focus on is what's said in the next paragraph, 103, where Lord Hamlin, or Mr. Justice Hamlin, as he then was, said the present case is one where there is no express choice of law in the matrix contract. In such a case, the Sul America decision is clear authority that the applicable law will be that of the country of the seat. Now, my lords, what my learned friends seek to say is, well, that's authority for the proposition that if there is only a clear demonstrated choice rather than an express choice in the matrix contract, Sul America, as Lord Hamlin said, is clear authority that the applicable law will be that of the country of the seat. Well, my lords, when I say so, paragraph 103 has to be read in light of the fact that in Habas, as is recorded in paragraph 99, and as we see later on at paragraph 120, there was no suggestion of there being a choice at all in Habas. It was a choiceless case, if I may put it that way. And paragraph 103 needs to be read in that light. Indeed, that is how it's been read in subsequent cases. And what I have in mind is the case of BMO versus BMP, which is in bundle. It's in the next bundle, I'm afraid, B29. And I'll just show this while we're on this dictum. I'll come to the decision in a slightly different context, but the relevant dictum, or relevant paragraph I want to show you is at page 1240 of the electronic bundle. It's a decision of the Singapore High Court, and it's paragraph 41 that's significant in this context. And just to set the scene, why this case is so important is because what it demonstrates is that the whole rationale behind the Sul America approach, being endorsed by the Singapore Court in BCY, which proceeds on the basis that a choice of law for the main contract is a presumption in favour of a choice of law, the same choice of law for the arbitration agreement. That presumption and that analysis is applicable even if the choice of law for the main contract is expressed impliedly or is reached by way of a clear demonstration rather than being an express choice of law. And in that respect, one sees that analysis from paragraphs 37 through to 39. And in my submission, that's entirely right. It's entirely consistent with our argument that there aren't qualities of choice. If you make a choice, you make a choice. And a choice within the first sentence of paragraph 3.1 of the Rome regulation is of no less value or more greater value than a choice within the second sentence of the same article. And that's why, having reached that stage of the argument, why it was necessary to consider paragraph 103 of Habas. And at paragraph 41, the learned judge says, I pause to note that the tribunal had cited the decision of Habas in its decision on jurisdiction. In that case, Nicholas Hamden J. Commented that in the absence of an express choice of law in the main contract, the applicable law of the arbitration agreement would be that of the seat. However, Hamden J.'s comment at paragraph 103 must be read in light of paragraphs 101 and 104, which clarify that his analysis relates to the third stage, i.e. the identification of the law, the closest real connection with the arbitration agreement. Since I find that there was an implied choice made by the parties, there is no need to proceed to the third stage of the inquiry. Now, my lord, that must be the right interpretation of paragraph 103, not least because both in Arsenovia and in Sul America, it was common ground that there'd be an express choice of law for the main contracts. So in other words, neither Sul America nor Arsenovia had to deal with the issue that may present itself in this case as to whether or not there's any material difference between an express choice within the first sentence of Article 3.1 and the second sentence of Article 3.1 of the Rome regulation. That point simply hasn't, in fact, it hasn't been expressly dealt with in an English authority. BMO, which was, of course, referred to the Court of Appeal in argument but wasn't considered in their judgment, is a demonstration, we would submit, albeit a decision of the Singapore Court, as to why, as a matter of analysis at least, there should be no difference between a clearly demonstrated choice and a one that's expressed by reference to a particular clause. Now, my lord, one final case which I want to refer your lordships to, and it's another decision of the Singapore High Court called BCY and BCZ. It's in bundle B28, and it's a decision by Mr. Justice Stephen Chong. And why this is significant is really threefold in my submission. Firstly, because...
Can you give us the electronic number, please?
I'm so sorry, my lord. Yes, of course. It's page 1214 of
Thank
the
you.
bundle. And
Yes.
why this decision is important is because it's a decision by the Singapore High Court, admittedly, but as your lordships will know, Singapore, alongside London and New York, are perhaps the leading common law, and Hong Kong, of course, the leading common law international arbitral centres. And what's significant about BCY is that the Singapore court sought to align itself with the English law position and adopted Sul America. And it did it in circumstances where there had been a prior decision in a case called First Link that effectively mirrored the same approach that the Court of Appeal took in our case. And what Sul America, the significance of Sul America, is that it considers both of those approaches, namely the approach in First Link, which mirrors that of Lord Justice Popwell in our case, and the case in Sul America, which mirrors that of Lord Justice Morbick in that case, considers the merits and demerits of both, and plumps very firmly for the view that the expressed judgment of Martin Morbick in Sul America has both the weight of authority behind it, and not only that, is more consistent with principle. And that's why, in my submissions of assistance, and the relevant paragraphs, if I may ask you to consider them in due course, in terms of time, if I could simply give you the reference, they are page 1220 of the electronic bundle, paragraphs 38, and the analysis runs through to page 1225, paragraph 65, where he concludes, based on Sul America, he says, where the arbitration agreement is part of the main contract, I would hold, adopting Sul America, that the governing law of the main contract is a strong indicator of the governing law of the arbitration agreement, unless there are indications to the contrary. The choice of a seat different from the law of the governing contract would not in itself be sufficient to displace that starting point. Now, my respectful submission, that is the orthodox position. That's consistent with Professor Briggs's analysis. It's consistent with the weight of authorities apart from XL and C versus D. And for the reasons that Mr. Justice Stephen Chong explains in BCY, it is sound as a matter of principle. He deals with some of the points that you will have to consider in this case on the arguments of my own friend and the judgment of the Court of Appeal. He deals with the same system of law point in paragraph 59. He deals conclusively, in my respectful submission, with separability at paragraph 60. And he also deals with neutrality at paragraph 62. And he also deals at paragraph 64 with the questions to the implication of Article 5 of the New York Convention. So he deals with all those points and nonetheless concludes quite correctly in our respectful submission that the Sul America analysis is correct. And we would commend his analysis to your lordships as a comprehensive and compelling one and indicative of the true state of English law. And it was building on that my lord, yes, Lord Burrows.
Very quickly, you've referred us twice to the views of Professor Briggs, but we've got various references in our documentation. Can you tell me precisely which part of his writings you're referring to?
My lord, I can.
Thank you.
My lord, I'm referring to his book called Private International Law in English Courts, and it's in bundle C 194, tab 194 at page 585 to 5866. Sorry, 5865 to 5866.
Thank you.
Perhaps we'll come to it, but I was going to actually turn it up because it's obviously important. If you followed the reference and got it on the screen, we can look at it now to save time later. It's at page 5865. And it's paragraphs 1437 through to 1438. And I won't read it aloud, but if you would be good enough to read it either now or subsequently, he deals compellingly and in a typical fashion with the question of separability. The autonomy of the arbitration agreement is one thing. Its hermetic isolation would be quite another. To put the point yet another way, the agreement to arbitrate is severable, but that does not mean it is separate. Prior to any severance, it will have been governed by the law which governs the contract. After severance, it must remain governed by the same law, for otherwise it is not being severed. Something else is being created. The result is that the law which governs the substantive contracts is identified by Rome 1. That law is very likely to govern the agreement to arbitrate, and will therefore also be used by the court to determine the validity, meaning, and scope of the arbitration agreement. My lord, that is, as he says at the beginning of 1439, that's the general principle. And indeed, we submit it is the general principle, and is sound in the sense that it's supported by the authorities. But in our submission, its justification is clear. and really, there are three principal justifications for that general principle as articulated by Professor Adrian Briggs. The first is that, as explained in cases like Sul America and BCY, which we've just looked at, when the parties enter into an arbitration agreement, there is a rebuttable presumption that they intend all of their substantive rights and obligations to be dealt with by the same system of proper law. The second justification is that, as Gary Bourne puts it in his writings, that this general principle has a plausible simplicity to it and an attraction that's consistent with commercial common sense. And then thirdly, is also consistent with the principle that depassage will not be inferred readily or without good reason. And to steal a phrase from, or coined by Lord Justice Toulson, I agree in a slightly different context, but nonetheless a pertinent one, it's not likely or easily to be inferred or implied that the parties to a contract intend to adopt what Lord Toulson called a harlequin proper law. It's highly unlikely that that's what the parties will, what you can infer or intend, that's what they meant to achieve, unless they used an express clause to achieve that objective. Now, what the Court of Appeal said, of course, is that presumption is actually reversed. And that's what we say is the fundamental error in the Court of Appeal's approach. They say that the proper presumption is that the proper law of the arbitration agreement will follow the curial law of the arbitration. Now, in our respectful submission, that analysis is based on a flaw, in particular, a failure properly to understand the distinctions between proper law and curial law. And obviously, Mr. Landau will be assisting your lordships shortly in that respect. But there are other aspects to why there's clearly a preference for the proper law in this context. And that is the fact that you don't need to have a curial law when you enter into a contract, or including one where there's an arbitration agreement. The Star Texas case conclusively demonstrates that the absence of a curial law for an arbitration agreement doesn't prevent it being invalid in any way. And secondly, the curial law, even if there's an overlap, Mr. Landau had explained that the Lone Friends case is exaggerated and wrong, but the reality is that the curial law is essentially irrelevant at the time the parties make and enter into a contract. And that's because what the curial law is really concerned with is what happens in the future if a particular contingency were to develop, namely the emergence of a dispute. And as Lord Diplock analyses arbitration agreements in Bremer Vulcan, that's a conditional concept that may or may not arise in the future. So it's natural, we would submit, that the parties would regard the proper law chosen from the very outset to govern all of their substantive rights and obligations under the contract. Now, my lords, if I can move on, and I have to, because obviously I've got quite a lot.
Lord Burrows has a question.
Yes, of course. My lord, Lord Burrows.
If I may, just before we leave Professor Briggs's writing, isn't it fair to say that he is not making anything of the fact that if you haven't got a choice, there is no presumption that the proper law of the arbitration agreement will follow the choice of seat? As I understand what he's saying is, whatever route you get to the proper law of the main contract, that whether choice or under stage 3, you end up with the starting point that the proper law of the arbitration agreement is the proper law of the main contract. He's not making, or am I misunderstanding something?
Well, my lord, I don't think you are misunderstanding. I mean, that is the natural consequence of what he is saying, that there shouldn't really be any difference with stage 3. The compelling part.
So that, if I might just interrupt, that contradicts what was said by my colleague Lord Hamblin in Habas. Is that right?
Well, no, Mr. Justice Hamblin was following what was said in Sul America and Arsenovia, which both say on those cases that the law with which the arbitration agreement has its closest connection is the curial law. So you're simply following those two cases. It is fair to say that we have decided, for whatever reason, to put our case on the basis of Lim 1 and Lim 2, in other words, Article 3.1 of the Rome Regulation. So that in essence, the third stage doesn't apply. But in my respectful submission, it would be open to me. It's not a point I'm taken, so I'm not suggesting I can or will take it. It would be open to me to argue that stage 3, taken as a holistic inquiry, would lead to the conclusion, certainly on some cases, that the law with which the arbitration agreement has its closest connection will be the proper law of the contract. We take the same point in a slightly different context anyway, because some of the elements of stage 3 and stage 2 do overlap, although they are conceptually. And perhaps the best answer I can give to Lord Burrows is to say that the third stage of the test will depend upon the facts of any particular case. And perhaps looking back at it, Arsenovia and Sul America shouldn't necessarily be taken as being conclusive that there's a universal rule to the effect that stage 3 always leads to the seed. So perhaps that's.
Thank you very much.
My lords, if I can, on this topic of proper law, there's a self-contained submission I wanted to make, which I'm going to condense, if I may, for the purpose of expedition. But what I would invite you to do is to consider the interplay between the choice of law rules contained in the Rome Regulation and the common law English rules. And the reason that's a relevant inquiry is because, as you will know, the Rome Regulation doesn't provide the complete answer to this case. And the reason it doesn't provide the complete answer is because arbitration agreements are excluded from its scope. And that's why, when considering questions of proper law in relation to contracts that include arbitration agreements, you have to take into account both the common law and the Rome Regulation. And the point I was going to develop is this, that if you were to take 3 cases, and they are Egon versus Liberia, decision of Mr. Justice Tony Clarksey which is at page 2899 of the electronic bundle. And you also were to take the case of Kebab, which is a Court of Appeal case earlier this year, at page 3338, and simultaneously the BMO case, which we've looked at, the Singapore case dealing with implied choices of law from the main contract applying to the arbitration agreement. That's at page 1232. If you take those 3 cases, we would respectfully submit that what they demonstrate is that, although separate, the 2 systems of choice of law rules, the common law and the Rome Regulation, actually are inextricably linked. And when applied in harness, they tend to produce complementary outcomes. And what I mean by that is that if you look at Egon, Oldendorf and Liberia, it concerned 2 contracts which had arbitration agreements in them. The first was an MOA, which had an express choice of law clause in the arbitration agreement. And the second was the Charter Party, which had an arbitration agreement which provided that the arbitrators were to be conversant with shipping matters. Now, in relation to the choice of law in the arbitration agreement in the MOA case, Mr. Justice Clark found that the choice of law, the express choice of law in the arbitration agreement, operated as an express choice of law for the main contract. In other words, it's the complementary side to the same coin as kebab. Because in kebab, you had an express choice of law in the main contract, said as a matter of construction to extend to the arbitration agreement. In the MOA case in the Egon, you had express choice of law in the arbitration agreement construed to extend to the main contract. And that parallel is also reflected in the decision of Mr. Justice Clark in relation to the Charter Party and the Singapore case BMO. Because in the Charter Party example, Mr. Justice Clark, as he then was, said that you could imply a choice of law from the arbitration clause in that case because it specifically referred to disputes arising out of an NYPE form involving shipping arbitrators and so on. So it went beyond the seat. But because of that, you can imply a choice of law from the arbitration agreement. And that choice of law from the arbitration agreement extended to the whole contract. So you have an implied choice of law from the arbitration agreement extending to the whole contract. And that is, again, in my respectful submission, the other side of the same coin as the BMO case, where you have an implied choice of law from the main contract also covering the arbitration agreement. So that's a significant, we would submit, feature of the way the two sets of rules work and leads to harmonious results. I'm sorry I've taken that rather quickly, but the cases are all in the bundles, and I hope you have the references to hand. What I would like to do now, if I may, is just to examine the reasons. There are 5 of them, which are advanced by both the Court of Appeal and my learned friends as being the reasons why greater weight, possibly in the Court of Appeal's case, overwhelming weight should be given to the curial law as being treated as the proper law of the arbitration agreement. And there are 5 reasons that have been given. The first is the concept of separability. The second is the doctrine of neutrality. The third is the relationship between the proper law of the main contract and the proper law of the arbitration agreement. The fourth is Article 5(1)(a) of the New York Convention. And the fifth is the relationship between the curial law and the proper law of the arbitration agreement. So those are the 5 factors, as I understand it, that have been relied upon from my learned friend's written case and the Court of Appeal's decision to justify affording, according to the Court of Appeal, overwhelming weight to the curial law. Now, of those 5, I'm going to address, if I may, the first 3, 1 to 3, and my learned friend Mr. Landau will address 4 and 5. Now, as far as the first of those reasons, separability, is concerned, that was the principal basis on which Lord Justice Popplewell rejected the analysis in Sul America. Now, in my respectful submission, that can't be right for the reasons I've already illustrated and demonstrated, namely that the concept of separability, although valuable, essential to the proper order of international arbitration, the reality is it's a function designed for a specific purpose, and that is to ensure the validity of the arbitration agreement is protected, notwithstanding the jeopardy to which the main contract may be put by some of the arguments the parties advance. And that doesn't apply, we would respectfully submit, in the context of the choice of law analysis. And that's particularly clear, we would say, from the judgments of Lord Justice Martin Morbick in Sul America, from Mr. Justice Stephen Chong in BCY, and indeed from Lord Justice Flo himself in Kebab, where he actually adopted the same analysis as we've been advancing, even though he agreed with what Lord Justice Popplewell said in our case. But that is we would submit what he said in Kebab is actually correct. Now, the second point or reason is the so-called the concept of neutrality. Now, in cases, and Egon is a good example, there are cases where the neutrality doctrine could be relevant to a choice of law analysis. And that's particularly the case where what has been demonstrated is that the substantive law that the tribunal will be applying to the dispute between the parties is a neutral law. But that simply doesn't apply in our case, because it's common ground that the substantive system of law that applies to determine the rights and obligations of the parties under the main contract is Russian law. So once that is accepted, the idea that some kind of neutrality could apply to the independent arbitration agreement analysis is, in my submission, unfounded. Having said that, there is one case, a recent case called Karpatsky, where Mr. Justice Butcher did take the neutrality of the seat into account as a relevant consideration for the purpose of determining the proper law of an arbitration agreement. But in my respectful submission, that's a very special case indeed, partly because it was a case where, not dissimilarly to Enka in our case, one of the parties was seeking to argue in Sweden that the proper law of the contract was X, whereas in England, for tactical reasons, they sought to argue that it was Y. Now, in that case, Mr. Justice Butcher said they were actually stopped by conduct from doing that, because I haven't taken a stoppable point against Enka, but that was the basis on which Mr. Justice Butcher approached it, and it was only Obiter where he just considered, well, if they could take the point, that's relevant. But he did so in circumstances, and this is.
I'm sorry, we're having a little interference, Mr. Bailey. Could you just repeat that, please?
Of course, my lord. I beg your pardon. I was referring to Karpatsky, and I was saying that the neutrality of the seat point was taken as an indicator in favour of the choice of the curial law, but it was in a particularly significant context whereby one of the parties was seeking to argue in one jurisdiction the proper law was X, whereas in the other jurisdiction it was Y. And more significantly, this was a case where the arbitration agreement was specifically and deliberately amended after the contract had been concluded to identify a neutral seat, namely the Stockholm Chamber of Commerce, as the arbitral institution. So those two features make it a very different case to ours. Now, as far as the third consideration, this is the interrelationship between the proper law of the arbitration agreement and the proper law of the main contract. This is a key feature, and it goes to what I started out with, the very first thing this morning, the questions I raised, because they will be fact sensitive and they will depend in every case upon the construction of the contract, and in particular, the interplay that exists or may not exist between the way in which the arbitration agreement operates within the context of the agreement within which it's embedded. And I sought to demonstrate this morning, I don't want to repeat the points, that there is inevitably a profound overlap between the way in which the arbitration agreement operates and the way in which similar, if not identical, obligations are expressed elsewhere in the contract. And that all leads to a very messy consequence if one tries to use your French dépassage slicing, sausage slicing machine and identify with precision which bits are governed by English law and which bits are governed by Russian law. And it's particularly difficult, and this is recognized in some of the academic commentary, in cases such as ours, where there is an ADR scheme built into the dispute resolution process, alongside with or integrated along with an arbitration agreement. That's a particularly pertinent area where it becomes very difficult to distinguish between the operation of the main contract and that of the arbitration agreement itself. And that's a point that is made quite convincingly by David Joseph in his book, trying to say I got the reference to immediately to hand, which apologies if I identify it, I will, but it's a second edition of David Joseph's book. It's the one that's referred to in Sul America itself. Yes, I can give you the reference. It's bundle C, tab 205, page 6283 to 6285. In my submission, if you look at paragraph 6.41, it's a compelling analysis as to why, in cases where the ADR provisions are interlinked with the arbitration clause, so there's a compelling basis for concluding that the law of the main contract interconnects with and overlaps with the obligation to arbitrate to such an extent that it points almost overwhelmingly to the conclusion that they ought to be governed by the same system of law. My lord, I want to I want to deal, if I may, with the so-called the Fiona Trust argument very briefly. What this argument is, as I understand it, is that if Russian law applies to this contract, that would frustrate the Fiona Trust principle, because it would mean that dispute is defined more narrowly according to Russian law than might be the case were English law to apply to the arbitration agreement. In my respectful submission, there is an obvious flaw in that argument, and that is the fact that the Fiona Trust principle is actually a substantive principle of English law, and it applies to the construction of contracts governed by English law. And in my respectful submission, it has no legitimate place in a necessarily anterior conflict of laws analysis. And the reason for that is because applying it in the conflict of laws analysis, which is an anterior inquiry that's self-contained, without independently having established that the contract is governed by English law, necessarily begs the question, because it really assumes the answer one wants to engineer. The second point is that the Fiona Trust point is not a universal guide, and I'd invite you to look at Ryanair in due cases, C93 at page 3975 of the electronic bundle at paragraph 49, where Lord Justice Ricks discusses the difficulty where issues of foreign tort law are involved. And then finally, we would submit that the approach of Russian law to the arbitration agreement, and indeed to the contract as a whole, doesn't frustrate the operation of clause 50. It simply makes it different, but it doesn't frustrate it. Now, my lords, I want to deal with rounds 2 and 3, and I want to finish before 3 o'clock to give my own friend Mr. Landau 45 minutes. So I'm going to take, if I may, the next parts relatively quickly. and they are, firstly, what is the proper law of the main contract? It's common ground that that's to be addressed and answered by reference to the Rome regulation. The principles, so far as I can discern from the written cases that are applicable, Lawler and the recent decision of Miss Dias as a Deputy High Court Judge in CGU, there doesn't seem to be any real major dispute between the parties. And the ultimate question in relation to the question of express choice of law in the main contract is the construction of its terms. And I've already helped to Lordships, both in writing and orally, as much as I can on that. What we submit, of course, is the Court of Appeal fell into error. They fell into error by relying upon the FIDIC forms, notwithstanding the fact that it's common ground that this contract, this particular construction contract, isn't based upon or drafted an application of a FIDIC form. And the short answer, in my respectful submission to this point, is that the contract in this case was a bespoke one. It wasn't based on the FIDIC forms, and it has to be construed in isolation from those other forms. As far as the clear choice aspect of Article 3.1 is concerned, what I'd ask you to do is bear in mind the Giuliano and Lagarde report, in particular at page 5591, where in the context of Article 3.1, a specific example is given of a contract that includes countless references, in that case, the French Civil Code in the contract. And we've set out in writing in our written case the numerous references way beyond the applicable law provision itself, where Russian law is repeatedly mentioned in the contract. And that's a highly relevant additional factor that is relevant to the question of clear choice. And the final area in this area of the case, where there is a dispute, as I see it, is in relation to the fact that whether there's any relevant subsequent conduct to the parties for the purpose of Article 3.1. It's common ground as a matter of principle, perhaps unusually for common lawyers such as ourselves, that for the purpose of Article 3.1, it is legitimate and appropriate to have a look at subsequent conduct for the purpose of identifying whether there was a clear understanding, a clear intention or agreement or choice at the time the contract was made for a choice of law. Although my learned friends quite rightly say, and I think this must be correct, that it's only subsequent conduct that actually casts light upon what their choice was at the time that's relevant. And I accept that must be right. But nonetheless, we submit there are two very important subsequent pieces of conduct that are highly demonstrative of the fact that parties clearly understood that there had been a clear choice of Russian law as the main law of the contract at the time it was concluded. The first is the motion for a stay that was filed by Enka in the Russian court proceedings It's in the appendix at 303 to 304, and I'm sure you will have seen it or will look it up in due course. But it's the paragraph in that motion where Enka expressly and unequivocally asserts before the Russian court that the applicable law clause, which we've looked at, constituted a choice of Russian law as the proper law of the contract. Now, why is that relevant as a piece of subsequent conduct? Is because it's inconceivable in my submission that Enka, a sophisticated commercial body, could have authorized its lawyers to put in a motion in those terms if it in fact had understood at the time that the reference to an applicable law clause was merely some form of FIDIC drafting technique. It's simply implausible that they could have considered at the time that the contract meant something different to what they authorized their Russian lawyers to say to the Russian court. And the second feature of the subsequent conduct is the assignment contract, whereby my clients insured and Enka entered into a contract together. And that's in the appendix as well at page 242 to 243. And the key point is paragraph 7.2. And I think there may be a misunderstanding on my learned friend's part of the point we're making. The point we're making is not simply that this assignment is governed by Russian law. The point we're making is that 7.2 contains a guarantee by Enka that the construction contract, i.e. the contract which contains the arbitration clause, was valid in accordance with Russian legislation. Now, my lords, we would submit that a warranty as to validity, which is, we all know, is a subject generally considered to be dealt with by the substantive proper law, a guarantee as to validity pursuant to Russian legislation is consistent with, and indeed only consistent with, we would submit, an understanding that the proper law of the construction contract was Russian law. So well, that's essentially a summary of our position on ground one of our appeal. Ground two is a particular point that arises in the context of the Rome regulation. My own friends seem to imply that it's simply wound up in ground one, but in fact it is an independent point. And it's an independent point because the argument that we make actually has weight and force, even if you were to find that the choice of Russian law for the main contract was pursuant to Article 4 rather than just Article 3. It applies whatever the basis on which you were to conclude that Russian law is the proper law of the main contract, particularly bearing in mind that's now common ground. And the reason it's an independent point is because it turns upon how you construe the scope of the arbitration exception from the Rome regulation. And the reason it turns on that is because it's only by reference to the construction of that exception that you can then apply it to our contract and identify which parts of our contract fall within the arbitration exception and therefore governed by common law, and which parts don't fall within the exception and therefore are governed by Russian law. And it's not an easy task. And I'm afraid to say I'm going to be short on this, partly because there's no authority on this point that we've at least been able to find. What we do have is two pointers or clues to the right answer. The first is in the Juliana and Lagarde report. The rationale for the exclusion of arbitration is that arbitration agreements are governed by other conventions. Now, if you apply that rationale to the construction of the exclusion, it becomes very difficult to see how ADR provisions, such as we have in clause 50.1, or the separate obligation to refer or right to refer disputes as to change orders to arbitration, difficult to see how those rights and obligations could properly be characterized as within the arbitration exception, given that they're not governed by any conventions at all. And the second point that may provide some guidance to you is this, namely that Professor Briggs, this is I think in a different book, My Lord Burroughs, different book, which I can give you the reference to, 5872 of the electronic bundles, makes the point that exclusions to European regulations are to be construed restrictively. And there's obvious merit to that, to create uniformity, that exclusions should only be construed as being applicable where absolutely necessary for that purpose. Now, if it's right to construe the exception restrictively, there are a number of consequences that follow from that. The first is, we've looked at it already, but and I'm sure you'll have it in mind, but if you look at clause 50, the only obligation to arbitrate is contained in one sentence followed by some bullet points. And if that's right, and if, as the Court of Appeal said, clause 50 as a whole must be an indivisible clause, given the fact that the balance of clause 50 must be governed by Russian law, then applying simple common law principles to the simple sentence, including the obligation to arbitrate, it must necessarily follow, otherwise the contract will make no sense at all, that the parties intended Russian law to apply to the whole clause. So that's essentially our point on ground 2. Which brings me, well, there's a final point. My learned friends also rely, as a fallback in relation to ground 2, they rely upon the extent of the exception to extract from the Rome Convention's grasp all the aspects of the ADR provisions and so on, get them out of the Rome Convention, put them into the common law and treat them as a self-contained package of Englishness. That's their first argument. But they have a second point, which is they say, well, even if that's wrong, and the arbitration agreement is narrowly construed just as the sentence with the obligation to arbitrate within it, if that's the only bit that's excluded, nonetheless, that itself constitutes a clear choice within Article 3.1 to trigger depassage in relation to all the other little bits of the contract which link in with it. So they're also clearly demonstrated, and that's the test they've got to meet, clearly demonstrated as being governed by English law. Now, my submission, that argument simply goes nowhere, because the mere choice of a seat, which is all they have, doesn't give rise to an implied choice of law, let alone a clearly demonstrable one. And their submission is, in my submission, directly contrary to Egon, where Mr. Justice Clark interpreted Article 3.1 in the context of English arbitration clauses as one that requires more than a seat, as consistently with Star Texas. You need more than a seat in the arbitration clause to demonstrate any choice of substantive law at all. So, well, that's ground 2. Ground 3. Now, this aspect of the appeal only arises if you allow the appeal on either grounds 1 and or 2. So the hypothesis on which ground 3 arises is that you've concluded that the arbitration agreement, like the main contract, is governed by Russian law. The reason I say that is because I accept that if the arbitration agreement in this case is governed by English law, then angelic grace principles apply, and there is no basis properly to disturb the Court of Appeal's exercise of discretion. So the injunction would follow, I accept that. So ground 3 arises on the hypothesis that that's not applicable as the proper approach, because this case is one where the arbitration agreement is governed by Russian law. And if you reach that position, then the question that arises, in a sense, is both conceptual and legal, but also a practical question, which is which court should decide the dispute as to the scope and application of the arbitration agreement to the dispute that's currently pending before the Moscow courts. That's the real question that arises, and there really are 2 possible answers. The first is the Russian court exercising their Article 2.3 obligation, which is the equivalent of our Section 9 of the arbitration agreement, or the English court as the court of the prospective seat pursuant to its jurisdiction under Section 37 of the Supreme Court Act, or sorry, the Senior Courts Act, as I should now call it. Those are the 2 choices. There aren't really any, there's no alternative choice that we would submit relevant here. And indeed, you also appreciate, as Lord Nance said in AES, that the power to stay court proceedings to arbitration under Article 2.3, which is what the Russian court is being asked to do, and the power to grant an anti-suit injunction to enforce a negative obligation not to litigate arbitral disputes, those powers are opposite, I think Lord Nance called them opposite and complementary sides of the same coin. And that's AES at page 646 of the electronic bundle at paragraph 60. that authority is also reported for 2 points while you have it handy. One is the fact that paragraph 48 of Lord Mance's judgment in AES, page 643, makes it clear that whether you call it the supervisory or the curial jurisdiction, whatever label you want to use, the significant point is the power to grant an anti-suit injunction to enforce the negative obligation arises not out of the lex arbitri. Sorry, I shouldn't use that word. It doesn't arise out of the law that governs the procedure of the arbitration, but it arises out of section 37 itself. And that's clear from paragraph 48 of Lord Mance's judgment. Sorry, judgment in AES. So in those circumstances where you have the position whereby the same point is pending before the court, which I've called the Article 2.3 court. I know I've been criticised for that, but as a shorthand, I could call it the Section 9 court if that's better. But the court who has the power and the jurisdiction to stay proceedings to arbitration pursuant to the New York Convention, on the one hand, and you have the court at the seat of the prospective arbitration with the power to grant an anti-suit injunction. What is the right answer to that dilemma? Now, as I say, there are two aspects, a practical one and a jurisprudential one. And indeed, there is a case where that precise dilemma presented itself before a well-known judge, Judge Rakoff from the Southern District in New York. He had that very dilemma before him. And if I may, I'd like to show you how he dealt with it. And that's a decision, as I say, of Judge Rakoff in PepsiCo. It's at tab 160 of the C bundles, at page 5392, 5392, 5393. It's a short case. And what had arisen in that case was a New York arbitration clause with a New York seat and a main contract governed by Venezuelan law. And there were proceedings pending in Venezuela. It's important to take the footnotes into account on page 5393 to follow it all together. There were proceedings in Venezuela which were being challenged by PepsiCo on the basis of a state arbitration. And there were proceedings in New York where PepsiCo was seeking an anti-suit injunction, or what we called a TO, or restraining order, by way of a petition to the district court in New York. It's exactly the same scenario as we have in our case. And the solution that Judge Rakoff came up with was a very pragmatic one. And what he decided to do was not to dismiss the petition. He retained jurisdiction over the petition, just in case, which on the facts of that case is understandable. What he did is he stayed the petition for an anti-suit injunction and granted a stay for 60 days to allow the Venezuelan court to decide the question of arbitrability. And he did that for three reasons. The first one is he regarded that as sensible case management. And that may be relevant when you come on to consider the decision that Mr. Justice Andrew Baker took in our case. But the first reason was sensible case management. The second reason was because it was consistent with what he regarded as the requirements of international comity. And then thirdly, he also considered it to be consistent with the reasonable expectations of parties who enter into a contract which they choose to govern by Venezuelan law, to anticipate the possibility at least that a contract governed by Venezuelan law might come up for consideration by a Venezuelan court. So those were the three reasons he gave for the decision to defer or restrain himself, exercise judicial restraint in the comity language, and allow the Venezuelan court to decide the questions to arbitrability. And we would submit to your lordships that there's an obvious attraction in terms both of sensible case management and jurisprudential legitimacy in terms of comity and discretion, which are the two relevant considerations here to that approach. Now, in terms of case management, as you know, the learned judge below, Mr. Justice Andrew Baker, decided of his own motion to stay the English proceedings. He didn't say that he dismissed them. Now, that is true. He did dismiss the proceedings, but he did that because there was an additional reason, namely the strong reason he found in terms of delay and so on. Those points no longer arise. But before Mr. Justice Andrew Baker, the reason he dismissed the proceedings was because there was a basis that justified doing that. But in terms of his analysis on discretion and form non-convenience, then proper analysis is he would have stayed the proceedings. Indeed, my own friends recognise that the power he had to act of his own motion in that regard was indeed a case management power. And that's apparent, we would submit, from a Court of Appeal decision called Cook and Virgin Media. It's at bundle B9 at page 814 to 826. And we can very briefly look at it. Find the right bundle. Sorry, I seem to have managed to open too many bundles. Forgive me a second. So, page 814. And what had happened in this case was that the judge below had, despite the absence of any challenge to the jurisdiction under Order 11, which is similar to the position that pertained when the matter was before Mr. Justice Andrew Baker, despite an application of CPR Part 11, that the judge below had the power of his own motion to effectively exercise his case management powers to stay or indeed strike out the case on the basis of forum non-convenience. And what he decided, what the judge had decided, which was totally upheld by the Court of Appeal, was that having looked at the court files and seen that the most appropriate forum to decide the cases was Scotland rather than England, notwithstanding the absence of any Part 11 challenge to jurisdiction, notwithstanding the fact that one of the defendants actually admitted liability. I mean, there is no more obvious form of submission to the jurisdiction than that. But admitted liability, notwithstanding all those features of his own motion on forum non-convenience grounds, he stayed the proceedings because that was the most just and convenient and sensible basis on which the case should proceed. And that power clearly exists in my submission. Whether it should be applied, in my respectful submission, depends on the circumstance of each and every case. And the fact that my own friends say, well, Mr. Justice Andrew Baker called them forum non-convenience features, and because of West Tankers, we've agreed to the English court having jurisdiction, it's not appropriate to exercise a forum non-convenience discretion. That's, I think, the way in which they put it. Now, my Lord, if I may say so, in a way that confuses, there's a bit of a labels point there, because what we would respectfully submit is that what we're dealing with here is a discretion that arises in the context of a jurisdiction under Section 37, which is a just and convenient. Those are the relevant words in Section 37, and in a context where comity is, in our submission, clearly relevant. The extent of its relevance is another matter, but relevant. And we're dealing with an equitable remedy. Now, the combination of all those three features, in my respectful submission, immediately infuses the court's engagement with the issue with a discretion. And
yes, Lord Leggett.
I'm not quite sure what you're saying, Mr. Bailey. Are you saying that you can salvage a bit of Mr. Justice Andrew Baker's judgment, even though other parts of it are flawed? Or are you saying that if the case goes back, the judge could exercise a discretion to stay the proceedings as one of the options available?
Well, my Lord, that's a fair question. And my Lord, what I'm saying is that the judge below Andrew Baker, Mr. Justice Andrew Baker, had the jurisdictional basis for the decision he made. And I'm really answering the point that Lord Justice Popplewell made, which is there was no legitimate basis in principle in which he could have even done that. And I
understand that, but what's the answer to my question?
Well, my Lords, we would submit that one would only remit this to the High Court in circumstances where you were to consider that the High Court ought to decide the point. The other appropriate way to deal with it, if you adopted Judge Rakoff's approach, is you would yourselves impose a stay pending the decision by the Russian courts, with remission after the stay, after the decision of the Russian courts had been announced.
Thank you.
But what? Sorry, I hope that's an answer, my lord. I think if your question was, if you remit, should the High Court in due course then defer? That's unlikely to be the case, because the basis for remission from this appeal to the High Court, prima facie, would be, if it was done immediately at least, would be to ensure the High Court decided it in place of the Russian court. If that makes sense.
Yeah. Okay.
I hope that's clear.
Yes.
But the significance of the significant point I'm seeking to make is to answer the argument in the written case from the respondents that forum non-conveniens is an irrelevant concept. And the point I'm trying to make, perhaps not very effectively, but the point I'm trying to make is that the better way of looking at it is, rather than calling the points that Mr. Justice Andrew Baker relied upon as forum non-conveniens considerations, is to simply look at them as being what I would call discretionary considerations. And if you avoid the labels of forum non-conveniens, simply refer to them as discretionary considerations and take into account the nature of the overall jurisdiction that you're considering, an equitable jurisdiction, based upon the exercise essentially of a discretion, it becomes much more understandable why the Court of Appeal's approach of effectively straitjacketing the court, saying ultimately the English court has to decide in every case. There is no scope for discretion because it's the prime, under the New York Convention, it says it's has the primary role as the court of seat, and you submitted to jurisdiction, therefore the English court must decide in every case. That lacks the sensitivity and the nuance that English law generally provides to ensure that the remedy fits the particular circumstance of any given case. So that's the Cook point, if I may call it that. The other points in relation to the court of the seat being the primary or superior court, we've dealt with those in our written case at some length. The key point there is that the analysis of the Court of Appeal breaks down in the sense that in other contexts, Dalla is a good example, the Burrito is another good example, the English courts do not afford primacy to the courts of the seat. So there's a lack of symmetry in the English law's approach if the Court of Appeal's decision on this point was right. And the other main issues, I'm sorry if I'm dealing with this rather quickly, are the questions of comity. And the points that are being taken against me are it's being said that comity is not relevant at all in the context of what's called a contractual case. Now, there are a number of answers to that. The first is we would submit that if you look at Mr. Raphael's book, it's at B41, perhaps if I can just simply give you the reference. If you look at paragraph 8.24, footnote 41, you will see that at least Mr. Raphael gives, by reference to authorities, justification for the argument that even in contractual cases, considerations of comity remain. Now,
can you give us the electronic page, please?
Yes, my lord. I'm sorry. It's page 1679.
Thank you. Yes.
What our submission is that the comity considerations are especially relevant when the English court is being asked to grant an anti-suit injunction to enforce a promise that is contained in or is otherwise subject to a foreign system of law, such as this case, Russian law. Now, as far as the analysis is concerned, and this perhaps in the last few minutes of my submissions is the point I want to emphasize, is that the fundamental flaw in my learned friend's case is apparent from paragraph 95 of their written case, which is at page 371 of the electronic bundle. If you perhaps would look at that. 371. And the flaw
Yes,
Sorry, I just need to find the right. Paragraph 95, and it's the sentence which says, in other words, the rationale for the angelic grace approach is the fact of the promise, not the law by which it's governed. That's, in my respectful submission, the reason that is fallacious is because the meaning and the scope and the effect of any apparent promise is determined by reference to its proper law. In other words, there is an inextricable connection between what the words of a promise say and the law by which you construe what they mean. The two are intimately connected, and it's for that reason why we would submit that in the context of the English court granting anti-suit injunctive relief for the purpose of enforcing a promise governed by English law, that comity considerations do not arise. And they don't arise for two reasons. One is there is the interest, talking in terms of Airbus and so on, what's the sufficient interest? The sufficient interest is provided by the combination of the fact the court has jurisdiction over the defendant and the fact that the contract is governed by English law. Those are the two features in harness which give, using Lord Gough's, I know Airbus was not dealing with contractual cases, but it's a useful seminal analysis of the concepts of comity. It gives the English, those 2 pointers in harness give the English court sufficient interest to grant an anti-suit injunction, which everybody now accepts after Turner and Provitt and after West Tag and so on, necessarily has an interfering impact, even if indirectly, upon the jurisdiction of the foreign court. And that significance, or that relevance of it, English law being the governing law, is demonstrable in my submission. It's demonstrable in the cases dealing with anti-suit injunctions. There isn't time, but I'm sure you will look at them. But in particular, the Painter Copper Mines case, one of the original examples of the courts in this country exercising the anti-suit injunction powers. If you were to look at that at pages 1090 to 1097 of the electronic bundle, you will see that there are constant references to the fact that the contract is governed by English law as being the justification for the interference that an anti-suit injunction had on Spanish proceedings. Then also, and we put this point in writing, in the Angelic Grace, there are references both by Lord Justice Millett and by Lord Justice Leggett to the fact that it's English law contract, an English law charter party, which justifies the English court essentially saying, irrespective of what the Italian court may think this promise, because it's an English law promise, it's totally appropriate for the English court to decide its meaning and effect. Perhaps the most telling indications as to why the choice of law is important in this context appear from two authorities, which again, in given the time, if I can just give you the references, they are in our written case, and they are the Highland Crusader, a decision by the Court of Appeal where the judgment was given by Lord Justice Toulson, as he then was, and in particular, it's at page 918 of the electronic bundle, paragraph 50.5, and then at paragraph 56. And also there are the references to the OT Africa case, to the judgment of Lord Justice Ricks, at paragraph 73, at page 3696 of the electronic bundle. And both of those cases, in the context which I've referred you to, demonstrate that the choice of law is a relevant consideration in the context of anti-suit relief. And the reason for that is, in fact, if I may say so, not difficult to discern. And it's this, that one of my learned friends' points, which I completely understand, is, well, the parties chose. They made a choice. They made a choice for a London seat. He calls it a package. Well, if it is a package, it's wrapped up in Russian wrapping paper. And that's the reality of the situation here, is that they also made a choice. They made a choice of Russian law, and that choice has its consequences. And one of the consequences is that there is a legitimate interest of the Russian courts, given it's the court whereby, and it's seized to the very same issue, which is, we would submit, clearly the most appropriate court to determine, not an easy point of Russian law, as having a justifiable basis for exercising that discretion, jurisdiction, I beg your pardon, without interference from the English courts. The reality is, my lords, that comity, equity, they are flexible bedfellows, and taken together, they do allow a court to do justice in any given case. I'm not, and I don't want to be thought to be suggesting otherwise, I am not saying that in every case, if there's a foreign law element, or even if the arbitration agreement is governed by a foreign law, in every case it follows the English court should not exercise its anti-suit jurisdiction power. I'm not saying that. There may be very good examples where it's still appropriate to do so. One of the points that my own friends say is, well, imagine the Nigerian courts were seized of the issue. It was a Russian court issue, Russian law issue, and the decision was, well, should the English court or the Nigerian court decide it? One can see that completely different considerations might apply. Likewise, one can imagine situations where a point is so obviously bad, and Judge Rakoff nearly got to this point, he didn't, but he stayed the proceedings because of it. So obviously bad, it's not even arguable. Or there may be a scenario whereby one can lead evidence that the foreign court's processes are such that the period of time it would take would simply frustrate the whole purpose. So plenty, and I can give many other examples, but what I'm ultimately suggesting to your lordships is that the straitjacket that the Court of Appeal has imposed is, in my respectful submission, unlikely, intuitively unlikely to be the right approach to the exercise of an equitable discretion, where the court is likely to want to fashion its result based on the detailed circumstances of each case. Lord, yes, Lord, my Lord Legate.
Yes, Lord Legate.
What do you say about the argument of policy or principle that if the parties have chosen London as a neutral forum, indicating what may underlie that might be, I'm not saying it isn't in this case, but it could be that they don't trust the courts of their respective jurisdictions to be an impartial forum, that policy is defeated if you have to go to the courts of one of those countries at the first stage in order to decide whether the arbitration comes within the scope of the clause or not, and that really to uphold that principle of neutrality, the English court ought to decide that point in support of the neutral forum. That's the gist of the argument.
Yes. Now, my lord, can I say that undoubtedly, and I accept, undoubtedly, that is a consideration to be weighed in the equitable scales. And I agree that that could well be a point the courts would want to balance out against the other features that I've identified. And exactly, if I may say so, I totally accept there is force in that point. But if you look at every case individually, and you look at the fact we are dealing with a case where there is a legitimate and difficult point of Russian law, the courts in Russia are engaged in it. It's the arbitrage court and the Court of Appeal. There's no suggestion. I mean, one can see from the fact that our case was completely dismissed on the merits that this is not a case where one could draw the inference that somehow we've got to, anyway, my lord,
So your argument is really on the facts of this case we should hold our hand.
My lord, my argument on grounds 1, grounds 2, and grounds 3 is ultimately what, and this perhaps goes to Edwin Peel's point. Should you have presumptions? Well, they may help. They may be signposts. But ultimately, the application of the principles of both common law and equity in this case have to be applied on a case-by-case basis, and it's unlikely to be a one-size-fits-all solution. And that, in my respectful submission, those are my points. I promised Mr. Landau to stop at 3, and I know I've gone a minute over, but unless I have any questions I can help with at this stage, those are my submissions.
Thank you very much indeed. We'll take a 5-minute break before hearing from Mr. Landau. Now, Mr. Landau.
May it please your lords, as foreshadowed by Mr. Bailey, there are 2 points that I wish to address. Firstly, the Court of Appeal's analysis on what they said was an overlap between provisions in the Arbitration Act on curial law and provisions governing the arbitration agreement itself. And then secondly, more briefly, the points now made with respect to Article 5.1a of the New York Convention. So if I can turn to the first of those. The focus of this argument is paragraphs 96 to 98 of the Court of Appeal's judgment. For your reference, that is tab 11 of the core bundle, pages 424 to 425 of the electronic bundle. The Court of Appeal relied upon as one of their a principal element in suggesting that the curial law should be connected to the arbitration agreement law. They relied upon what they said was an overlap in the Arbitration Act, such that when parties contract into the Arbitration Act, they are at the same time, or when the Arbitration Act applies, they are at the same time being faced with provisions in the Act that bear upon the arbitration agreement itself. And the Court of Appeal identified specifically sections 5, 6, 7, 8, 12, 13, 14, 30, and 66 to 68 of the Arbitration Act. This point has been picked up by Enka, paragraphs 26 to 36 of its written case. And this is the first of the 4 reasons that Enka gives in its written case for treating a choice of seat as indicative of a choice of law to govern the arbitration agreement. There are 2 separate points that I wish to address on this, neither of which, in my respectful submission, were actually addressed properly by the Court of Appeal or have indeed been addressed properly by Enka. The first one is the operation of section 4.5 of the Arbitration Act, 1996. And then secondly, but more shortly, the operation of section 4.3 of the Arbitration Act, 1996. Let's turn to the first of those. The Court of Appeal overlooked the fact that there is a whole regime built into the Arbitration Act 1996 to deal with this issue. What is critical to note is that of the provisions that the Court of Appeal identified as suggesting an overlap, most of them are non-mandatory. In fact, all of them, apart from sections 12 and 13 and 66 to 68, are non-mandatory. That takes us to the structure of the Arbitration Act 1996. It's divided into mandatory provisions and non-mandatory provisions, and in particular, section 4 of the Act. Could I ask your lordships to turn that up, please? That is at electronic page 1274. It's in the primary authorities at tab 31. 1274.
Yes.
Headed mandatory and non-mandatory provisions. 4.1 explains that the mandatory provisions of Part 1 of the Act are listed in Schedule 1, and they will apply notwithstanding any agreement to the contrary. 4.2 then refers to the non-mandatory provisions, which allow the parties to make their own arrangements by agreement. 4.3 makes the point that those arrangements by agreement can include an agreement to apply institutional rules. But critically, for my purposes at the moment, is 4.5. 4.5 provides as follows: the choice of a law other than the law of England and Wales or Northern Ireland as the applicable law in respect of a matter provided for by a non-mandatory provision of this part is equivalent to an agreement making provision about that matter. And then, for this purpose, an applicable law determined in accordance with the parties' agreement, or which is objectively determined in the absence of any express or implied choice, shall be treated as chosen by the parties. Now, what's been set up here in the Arbitration Act is a particular mechanism to avoid the consequence that follows from the Court of Appeal's judgment and from Enka's submission. And that is that by a choice of seat, and the application of the Arbitration Act 1996 by virtue of that choice, other distinct parts of the arbitration process will then also be naturally governed by English law, such as the arbitration agreement. That was something which the DAC wanted to avoid in terms, and they explained that specifically in the DAC reports. That, of course, is squarely contradicted by the Court of Appeal's conclusion and Enka's case that the choice of seat will lead to a choice of law for the arbitration agreement. The best place to get the explanation for this is the DAC reports, and in particular, the DAC supplementary report of January 1997. If I can ask your lordships to turn that up, that is at electronic page 5535. It is tab 174 of the C series. And in particular from page 5536, headed Chapter 2, Part 1 of the Act, Section 2, Scope of Application. So to understand the operation of Section 4.5, one needs to go back to actually Clause 2 of what was then the Arbitration Bill, now Section 2 of the Act. That sets out the scope of application of the Act. When does the Arbitration Act 1996 actually apply? Broadly speaking, it will apply when the seat of the arbitration is in Wales or Northern Ireland. But more detail was needed because, of course, some parts of the Arbitration Act will bear upon an arbitration agreement. There are different ways of characterizing different provisions. And so there was a detailed regime originally set out in the Arbitration Bill, which is set out and explained in paragraph 6 of this report. If I can just take your lordships through this, it's a little detailed, but it is essential in understanding Section 4.5 of the Act as it finally was passed. So from paragraph 6, Clause 2 of the bill, as introduced in the House of Lords in December 1995, read as follows. 2.1 is uncontroversial. The provisions of this part apply where the law of England and Wales or Northern Ireland is applicable, or the powers of the court are exercisable in accordance with the rules of the conflict of laws. That's a neutral provision, simply saying if the rules of conflict of laws tell you that English law applies, then this applies. More relevantly is Clause 2.2. That read, they apply in particular, A, to matters relating to or governed by the arbitration agreement, where the applicable law is the law of England and Wales or Northern Ireland. And B, to matters governed by the law applicable to the arbitral proceedings, where the seat of the arbitration is in England and Wales or Northern Ireland. So what was set up was the idea that if English law governed the arbitration agreement, then the Act would apply to matters relevant to the arbitration agreement. And secondly, distinctly, if the arbitral proceedings were to be governed by English law, or the arbitral proceedings as far as the seat is in England, that would then be a separate category governed by English law. Just going down to paragraph 7, this is explained further as follows, just picking up from the last sentence. The basic elements of this clause, as originally drafted, may be summarized as follows. If I could just go down to 7 sub 2, Clause 2.2 as originally drafted further refined the basic principle by recognizing that different elements in arbitration may well be governed by different laws. The law governing the merits of the dispute, e.g. a choice of law clause in a contract, may not necessarily govern the arbitration clause itself, as the latter constitutes a separate agreement. Similarly, the law governing the procedure of the arbitration may well be a different law from that governing the merits of the dispute. Consequently, if the arbitration agreement was governed by English law, those provisions in the Act which concern arbitration agreements would apply. That's Clause 2.2a. Similarly, if the seat of the arbitration was in England and Wales or Northern Ireland, those parts of the Act which concern the arbitral procedure, as distinct from matters of substance, would apply. Clause 2.2b. This further refinement was necessary in order to avoid the danger that all the provisions of Part 1 of the Act would be imported if English law is found to govern one particular aspect of an arbitration. For example, an arbitration may have a French seat with French law governing the procedure, but English law governing the arbitration agreement. In such a situation, only those provisions of the Act which concern arbitration agreements should apply. It would be quite wrong to apply provisions of the Act which concern arbitral procedure, as this would be governed by French law. Indeed, if this were not the case, a choice of English law to govern an arbitration agreement would entitle a party to invoke the jurisdiction of the English court, wherever the seat of the arbitration might be, endowing the English court with an unacceptable extraterritorial jurisdiction. So that was the idea behind the original clause 2 of the bill. Going down to paragraph 9, it then explains what then happened in the drafting. Paragraph 9, following the introduction of the bill into Parliament, we had the benefit of further detailed discussions with a number of leading arbitration experts from abroad and took the opportunity of reconsidering this provision. It is fair to say that whilst there was unanimous support for the inclusion of such a provision identifying the scope of the Act, there was considerable disquiet as to the clause as drafted. It was felt that the provisions were sound in principle, but unworkable in practice for the following reasons. And then 1, 2, and 3 are set out, which are really just the idea that the drafting was overly complicated. That takes us down to paragraph 10. Paragraph 10 said, in the light of these difficulties, the DAC decided to recommend recasting the whole provision in a different form that would be far easier to understand and that would be entirely workable in practice. But then, importantly, the following is said, the policy behind this section, however, was not materially altered. Not materially altered. And then going down to paragraph 12, lastly. Paragraph 12, if this is now commenting on clause 2 of the Act itself as it was finally passed. If the seat of an arbitration is in England and Wales or Northern Ireland, the arbitration will be governed by this Act. If, however, a foreign law has been chosen to govern any particular aspect of the arbitration, such as the arbitral procedure or the arbitration agreement, or is otherwise applicable to any such aspect, this is catered for by section 4(5). Therefore, reference may be made to this Act in the first instance, and then back to another law with respect to a specific issue. Whilst a process of characterization may still have to be done, the combination of section 2 and section 4(5) avoids the dangers that, firstly, a choice of English law with respect to one part of an arbitration will import other parts of the Act that concern other aspects of the arbitration. And secondly, a choice of England as the seat of the arbitration will necessarily entail the imposition of every provision of the Act. My Lords, I'm sorry if that's a long read and may sound rather complicated, but the nub of this case is actually within that explanation. The mechanism in section 4(5) of the Act has finally passed into law, allows for the application of a different law to the arbitration agreement from the law of the seat. If that is done either expressly or impliedly, or if the arbitration agreement is governed by a different law simply by the objective application of conflicts rules, that's enough to exclude all the non-mandatory provisions that are relevant to arbitration agreements. So there's a question of characterization that has to be done. It will only apply, a foreign law governing an arbitration agreement will only exclude provisions in the Arbitration Act that are relevant to an arbitration agreement. It won't exclude any other provision, and it will depend on what the foreign law provides. But what this militates against specifically is the Court of Appeal conclusion that naturally, or by way of some presumption, the law of the seat will dictate the arbitration agreement law. that policy should perhaps be compared with paragraph 29 of Enka's written case. I don't know if your lordships will have that to hand, but paragraph 29 is drafted in such a way as flatly contradicts what the DAC was trying to achieve. I think perhaps for the sake of time, I'll just give you that reference to compare paragraph 29 to the DAC report that I've just read out. Now, there are two arguments that are now raised against this, or by way of response, two principal arguments by Enka. The first argument is that section 4.5 only refers to the curial law. It doesn't include choices of law for the arbitration agreement. That's the first one, first answer that's given. That's paragraph 32 of my friend's written case. And the second is that section 4.5 actually includes an additional requirement, albeit it's not set out in the section. It will only be operative if there is not only a choice of foreign law, but if the parties specifically identify a provision in the foreign law which they want to use to displace a provision of the Act. So an additional specific reference requirement. That's paragraph 33. Neither of those are sound points. If I can address each of them in turn as quickly as I can. Firstly, there is no doubt at all, contrary to Enka's case, that section 4.5 of the 1996 Act refers to the law. It includes the law governing the arbitration agreement as well as the curial law. There can be no reasonable doubt about this. Just to pause for a moment, if Enka is correct, section 4.5 doesn't include a choice of law for the arbitration agreement, then presumably, even if the parties had expressly chosen a specific law to cover their arbitration agreement, and that law contains provisions that are different to the non-mandatory provisions of the Act on arbitration agreements, it's tough luck, according to them. The non-mandatory provisions will still apply. That makes a nonsense of what the DAC was trying to achieve. But there are a number of points to show why this cannot be correct. Firstly, the text of section 4.5 itself. It's plain from the text that it refers to any applicable law. It will include all aspects of the arbitration. There is simply no exclusion in the wording or no limitation in the wording of section 4.5 to restrict it to curial law and to exclude the law governing the arbitration agreement. At paragraphs 32.1 and 32.2 of Enka's written case, there are some attempts at a textual argument by reference to section 4.4 and section 4.3 of the Act. Those are manifestly bad points. There's nothing in 4.4 that tells you about the scope of section 4.5. There's nothing in section 4.3, which is a specific provision about institutional rules, that tells you about the scope of 4.5. If there were any doubt about it, it's made absolutely crystal clear by the DAC report that I've already shown your lordships. The DAC January 97 report explains in detail why the DAC wanted to include the law governing the arbitration agreement, as well as the law governing the procedure. The only answer provided in Enka's written case to this is footnote 39, where it said that the DAC report is ambiguous. But it's difficult to see how it can be ambiguous given the length and the detail of the analysis. Then Enka relies upon two authorities for this proposition. This is at paragraph 32 of their written case. They cite Dubai Islamic Bank and Payment Tech. That's at Electronic Bundle 2826. I don't have time to pull it up. With your Lordship's permission, I'll just give you the references. They rely upon paragraph 31 of the judgment of Mr. Justice Aikins, as he then was. But if you turn up that paragraph, you will find no support for this proposition at all. The Dubai Islamic Bank case didn't need to address the law governing the arbitration agreement. It simply wasn't a matter for discussion in the course of the argument or the judgment. The only point that Mr. Justice Aikins made in that case was about procedural law. He wasn't referring to the law governing the arbitration agreement, so it's of no assistance. Similarly, secondly, Enka relies upon the case of C versus D, the judgment of Mr. Justice Cook in 2007. This is Electronic Bundle, page 703. And Enka relies upon, in particular, a comment at paragraph 38 of the judgment. Again, that judgment is of no assistance on this point at all, because the argument in that case was not focused upon the law governing the arbitration agreement. The argument in that case concerned whether the law governing the substantive merits of the matrix contract was sufficient to displace Section 58 of the Arbitration Act, which is about finality of awards. So there was no need to discuss the arbitration agreement governing law. In terms of commentaries, leading commentaries are clear, if this is needed, that the law governing the arbitration agreement is also included within the ambit of Section 4.5. I'll give you the references, in particular, Merkin and Flannery at Electronic Bundle, page 1564, paragraph 4.3 of that text. And secondly, Professor Adrian Briggs at Electronic Bundle 1376. Actually, that's where the excerpt begins. The relevant point is at Electronic Bundle reference 1407. That might be worth quickly turning up, actually, if you wouldn't mind. So that's in the Primary Authorities, tab 35. 1407. Give me just quickly find that reference. There's an excerpt which begins, all other provisions of Part 1 of the Act, if you have that. All other provisions of Part 1 of the Act are non-mandatory, and these apply only to the extent that the parties have not made their own arrangements in the agreement. They are the default options. Then he says, but the Act also provides that if the arbitration agreement is governed by a law other than English law, that simple fact suffices to constitute an agreement to make contrary provision. As a result, the mandatory rules must be applied, whatever the law which governs the arbitration agreement. The non-mandatory rules will apply only when the law governing the arbitration agreement is English law and the parties have not agreed on particular provision to the contrary. Then, lastly on this point, there are a number of policy reasons advanced by Enka as to why the law governing the arbitration agreement should not qualify under Section 4.5 to displace the provisions of the Act. These are set out in particular at paragraph 32.3 of my learned friend's written case. They say that this interpretation will cause vast swathes of the Arbitration Act to cease to apply. I think this is, they say, even where the parties have made no choice of any foreign law, but have chosen London as the seat of arbitration. I think this qualifies as a submission in terrorem, but it is misplaced because it misses the requirement of characterization that was mentioned in paragraph 12 of the DAC January 1997 report. If a foreign law applies to the arbitration agreement, either by express or implied choice, or by the objective operation of the rules of the conflict of laws, the only things that will be displaced will be provisions of the Act that are relevant to the arbitration agreement. That's the point about those paragraphs that I read in the DAC report. It will not, of course, one has to do a characterization exercise, but that choice of foreign law or the application of the foreign law will have no impact on any provision in the Act which doesn't concern the meaning or scope of the arbitration agreement, or the nature of an issue which is inherently an issue controlled by the law governing the arbitration agreement. Now, that will be clear in many cases. In some cases, it may require a difficult exercise of characterization, but that will have to be done. And part of that will be to look at what the foreign law actually is providing. But this is a specific exercise which the DAC had well on their radar. It's no answer to sweep it all away and say, well, actually, we must do away with all of that. There must be no characterization. On the contrary, a different rule is to apply. All those points go to the first of the two Enka points, which is that Section 4.5 is limited to curial law. Patently, it's not. Let me then turn to the second point that's raised. And this is at paragraph 33.1 of my learned friend's written case. It said that Section 4.5, even if it includes the law governing an arbitration agreement, will only apply if, in their choice of the foreign law, the parties have made specific reference to the particular provision of foreign law, which they say displaces a non-mandatory provision of the Act. So it's an additional specific reference requirement. There is no such requirement in Section 4.5. This is a bad point for a number of reasons. Firstly, text. The text of Section 4.5, which I've already read, is crystal clear. What it says is, I don't know if you still have it in front of you, it's electronic bundle 1274, if that helps.
Yes, yes.
What it says is that the choice itself will be equivalent to an agreement about a non-mandatory matter. The choice itself. That's enough to displace a mandatory provision. But more than that, the final sentence of paragraph 4.5 puts this point to bed. Because it's not just a choice, it's the objective application of the rules of the conflict of laws. If the objective application of a conflicts rule is enough to displace a non-mandatory provision, there is simply no room whatsoever for a further requirement to make a specific reference to the particular provision of foreign law that's relied upon. Just doesn't work. That is a short and complete answer to this point. There is an attempt at a textual response, which is it's paragraph 33.4a of my learned friend's written case, where reliance is placed on the wording in Section 4.5, a choice in respect of a matter provided for. In respect of a matter provided for. Now, that is said to give rise to this additional requirement of specific identification of the foreign provision. Actually, it does no such thing. That wording reflects the policy, the characterization point that underlies this provision as explained in the January 1997 DAC report that I've already taken your lordships to. The phrase, in respect of a matter provided for, allows you to distinguish between those matters that concern the arbitration agreement and those matters that concern the arbitral procedure. There's no way that one can use that to read into the provision a further requirement. Now, where this point has come to life from is authority. And I do need to, as fast as I can, take you through how this point has come about, because one sees this point reflected in 3 cases that have been referred to in some commentaries. These are cases relied upon by Enka in paragraphs 33.1, 33.2, and 33.3 of its written case. C versus D, judgment of Lord Justice Longmore, the judgment of Mr. Justice Burton in the National Iranian Oil Company case, and both of those relying upon and citing a comment of Lord Steyn in the Lesotho Highlands Improgilo case. Because the two cases of C&D and National Iranian Oil rely upon Lesotho, it makes sense to begin with Lesotho. And a remark by Lord Steyn that has given life to this point. I'm very, very short of time, so I'm going to dash through this in the hope that I'll be stopped if your lordships would like me to take you to any of these references. Lesotho is at electronic bundle number 1001. The context of the case was a Section 68 application to set aside an arbitral award. The arbitration was an ICC arbitration with a London seat. The governing law of the main contract, the matrix contract, was the law of Lesotho. There was a challenge as to whether the tribunal had power to award interest in the way that it did. It would have had power, certainly under Section 49 of the Arbitration Act. The challenge came on the basis that it had no power under the law of Lesotho. And Section 49 of the Arbitration Act was displaced by the law of Lesotho. So that's how this point arises. If you have the judgment open from page 1017 of the electronic bundle, let's quickly turn that up actually. Paragraph 35 is where the relevant analysis begins in the judgment of Lord Steyn. Actually, the basis for the Lesotho decision is described in the last 3 lines of paragraph 35. That's electronic bundle number 1018. The finding was premised upon there being no evidence of substantial injustice. And therefore, that was actually what was fatal to the challenge that was being made. But having decided that, at paragraph 37 of his judgment, there's a comment by Lord Steyn, and this is the relevant paragraph that has been relied upon by Enka and picked up in the other 2 cases. Paragraph 37, just reading this, Lord Steyn said, Mr. Justice Morrison appeared to take the view, this is at first instance, that the law of Lesotho, as the law applicable to the construction contract, may be relevant. This presumably is on the basis that it constitutes an agreement to the contrary under Section 49. Ignoring for the moment the fact that one does not know what the law of Lesotho is, this view comes up against the difficulty that only an agreement in writing, as defined in the Act, can qualify as an agreement to the contrary under Section 49, and that's a reference to Section 5.1. This is no mere technicality. In the words of the DAC, page 14, paragraph 35, by introducing some formality with respect to all agreements, the possibility of subsequent disputes is greatly diminished. Now, it's that comment that has given rise to this point. I can do no better than refer to a masterful analysis on this point by the late Johnny Vida, QC. That is at the bundle at electronic page, the article begins at electronic page 7527. It's at tab 266. As your lordships will be well aware, Johnny Vida was one of the chief architects of the 1996 Act. Tragically, Johnny Vida passed away a few months ago. He will be sorely missed, and it seems somehow fitting for Johnny Vida to make the following submissions rather than me, because this was a point that he has addressed specifically in this article. Can I ask your lordships to turn in this, this article to electronic page 7528. Under the heading interest, Mr. Vida begins by saying the issue of pre-award interest is different. It results from an unfortunate misunderstanding of a judgment of the House of Lords on the 1996 Act, Improgilo and Lesotho. This misunderstanding is widely shared and has made legal commentators more than cautious. And then he goes through the circumstances of the case in the following paragraphs. If I can ask your Lordship to turn to page 7529. I'm skipping because I'm now short of time, but if I can ask your Lordships in your notional spare time to perhaps read the article carefully, Mr. Vida goes through the policy of the DAC as reflected in section 4.5 of the Act. He makes the point that Lord Steyne did not make any reference in Lesotho to section 4.5, which is odd. And then he proceeds to explain how it is that section 4.5 actually answers this point. Instead of going through this bit by bit, let me just summarize the points that Mr. Vida makes. He says that what Lord Steyne must have meant was that there was no evidence in that case on Lesotho law. Because there was no evidence at all, the requirement of an agreement in writing for the purposes of section 5 of the Act was not met. But that's the only issue. The point cannot be taken to mean that there is some additional requirement of a specific reference to the provision in question. He says from his page 382, page 7531 of the bundle, that any such additional requirement would be inconsistent with the text. It will be inconsistent with the DAC reports and the legislative intentions, that it's not found in Lord Steyne's analysis. He then says that it would make a practical nonsense of the Arbitration Act 1996 because it would force parties, when they make their arbitration agreements, to append the equivalent of Chitty or Halsbury's, listing all the particular provisions that they rely upon in the foreign law. Needless to say, that is not consistent with commercial practice. In Mr. Vida's words, it would in effect make non-mandatory provisions of the Act mandatory. That would undermine party autonomy, and he says it would cast doubt on even the efficacy of agreeing to institutional rules. Because why wouldn't the same apply for that? Section 4.3 of the Arbitration Act 1996, which refers to institutional rules. If there's a specific requirement referenced, then presumably it's not enough to rely upon generally the ICC rules or the LCIA rules. You would have to identify specifically every provision that you're relying upon to displace a non-mandatory provision. And he ends up with his own inter aurem submission, which is that this would do serious damage to London arbitration. That's at page 7532. My lords, that really means, given the analysis of Lesotho, which is relied upon in C versus D and the National Iranian Oil Company case, that I needn't go to those other judgments because they are premised upon a misunderstanding of this particular point. There are further policy reasons which are highlighted by Enka to suggest that a specific reference is a safeguard and that it's important because otherwise there will be difficulties if one doesn't have that safeguard. Well, that is something which the DAC could have implemented, but they obviously chose not to. And on the other hand, they were protecting, as Mr. Vida has explained, party autonomy by giving full flexibility to contract out of the non-mandatory provisions. I just want to pick up on one further point on this, which is paragraph 34 of Enka's written case. It's said there that this analysis of section 4.5 will likely lead to parties to London arbitration excluding non-mandatory provisions which they would never have intended to exclude. And the reference is made there to sections 5, 7, 30, and 58. Again, the error that is made by Enka is a failure to do a characterization exercise. Sections 30 and 58 do not concern the arbitration agreement. They're not matters that are controlled by the law governing the arbitration agreement. So unless the agreement is particularly specific, they will not be affected by a reference to a foreign law to govern the arbitration agreement. As for Section 5 of the Act, a lot is made of this, but it is misunderstood with great respect. Section 5 of the Arbitration Act contains a scope provision. It is a writing requirement provision. Section 5 of the Act, which is electronic reference 1320, does not tell you whether an arbitration agreement is valid or not. It simply tells you whether the Arbitration Act 1996 applies. It's said by Enka that a foreign law may say something different about writing. That won't impact on Section 5. Whatever a foreign law says about writing, Section 5 has its own test, which will apply unless it's specifically excluded in the foreign law. So if you want to know whether the Arbitration Act applies or not, you simply apply what the test is in Section 5. You'll do that whatever the governing law of the arbitration agreement. Section 5 will only be displaced if, which is extremely unlikely, a foreign law says something specifically about Section 5.
Right, well, I think I'd have to ask you to wind up now, Mr. Lambert.
Yes. So I apologize for taking long. Those are my submissions on Section 4.5. Section 4.3 can be briefly stated. Section 4.3 of the Arbitration Act allows non-mandatory provisions to be displaced by institutional rules being incorporated. The Court of Appeal never took into account the significance, in this case, of agreeing to the ICC rules. Even aside from Section 4.5, an agreement to the ICC rules will displace almost all of the provisions upon which the Court of Appeal relied as being overlaps. And so there isn't any significant overlap because the parties have actually chosen the ICC rules instead of the 96 Act. Finally, Article 5.1a of the New York Convention provides really no assistance. And I'll just give your lordships some references on this. This is in response to paragraph 39 of the Learned Friend's written case. Article 5.1a of the New York Convention provides grounds for resisting recognition and enforcement of arbitral awards. You'll find it in the bundle at electronic 1355. It says that it refers to the law to which the parties have subjected their arbitration agreement or failing any indication thereon under the law of the country where the award was made. Two brief points. Firstly, this is interpreted by Enka as saying if there's no express agreement or express designation of a governing law for the arbitration agreement, then it must be the law of the seat. That is wrong, because Article 5.1a has been interpreted as including express or implied designation. And the reference for that is in the UNCITRAL Guide to the New York Convention. This is at the further additional authorities that we've introduced, electronic reference 7606. It tells you, and this is UNCITRAL endorsed, which is the body responsible for the New York Convention, that Article 5.1a will include an implied choice of law, and that implied choice of law may derive from the law governing the main contract before you get to the default rule. Secondly, lastly, Article 5.1a cannot give you a default conflicts rule for all purposes. It wasn't designed for that. It's designed for the final stage of recognition and enforcement of awards. It only refers to validity of an arbitration agreement. Doesn't refer to scope or interpretation. Doesn't refer to other factors that are normally governed or controlled by an arbitration agreement law. And lastly, as Mr. Bailey has already observed, it can't be a default rule because in many cases, you will not know the seat until much later in the proceedings. And that's often because seat will be designated by the tribunal or some other court. My lords, I'm sorry for having rushed through the points and for having gone into injury time. But those are my submissions.
Thank you very much indeed, Mr. Land. Now, Mr. Dicker.
My Lord, Enka submits the Court of Appeal's judgment is correct for the reasons given. There are 3 short points. Firstly, by agreeing to arbitration in London, the parties submitted to the jurisdiction of the English court to grant an injunction to restrain any breach of the arbitration agreement. And in that context, they also agreed that the English court could determine the scope of the arbitration agreement and the question of whether there is a breach. Secondly, the proper law of the arbitration agreement in this case is English law, in which event Chubb accepts it's in breach. Thirdly, the English court will grant an anti-suit injunction to restrain Chubb's breach of contract absent strong reason to the contrary, and there is no strong reason in this case. We say Chubb's case is wrong as a matter of law and principle, and acceptance of it would have undesirable implications for English arbitrations. Lords, firstly, on Chubb's case, a party can commence proceedings in its preferred court and insist that it must be allowed to continue those proceedings unless and until the foreign court decides otherwise. There's a pithy comment by Lord Mance in the front coma case, which your lordships have in the electronic bundle at 1196.
Yes.
It's the last 2 paragraphs, 31 and 32. But the passage I wanted to cite was 32, where Lord Mance says, "It is in practice no or little comfort or use for a person entitled to the benefit of a London arbitration clause to be told that, where a binding arbitration clause is being, however clearly, disregarded, the only remedy is to become engaged in the foreign litigation pursued in disregard of the clause. Engagement in the foreign litigation is precisely what the person pursuing such litigation wishes to draw the other party into, precisely what the latter party aimed and bargained to avoid." We say that that is precisely what Chubb is saying in this case. Chubb's case is that contrary to the regime, to the package of rights and obligations that the parties agreed to, and it would also require the English court to abrogate its role in supervising, supporting, and if necessary, enforcing the arbitration agreement. The sole justification given for this is that Chubb says the arbitration agreement is governed by Russian law and that the Russian court is best able to decide what it means. We say the basic problem with this is that we're not concerned with which court objectively is best able to decide questions of Russian law. We're concerned with what the parties agreed as to how their disputes would be resolved. And by choosing London as the seat of arbitration, we say Chubb agreed to submit to the jurisdiction of the English court to determine whether it's in breach, irrespective of its proper law, and to grant an anti-suit injunction. And Chubb cannot object if that is what the English court does. Secondly, we say that Chubb's approach to determining the proper law of the arbitration agreement is also flawed. The short answer in this case is that the arbitration agreement here is governed by English law and not Russian law, in which event, as I've said, Chubb accepts the appeal should be dismissed. And the reason we say that is because the parties agreed the seat of arbitration is London. And we say this choice of seat was an implied choice of English law as the proper law of the arbitration agreement. So what one might ask can go in the scales on the other side. Answer, we say nothing. In particular, there's no express governing law in the main contract, let alone one that might be capable of overriding parties' implied choice implied from their choice of seat. And absent any such express clause, there's no basis for concluding that the arbitration agreement is governed by English law. Lords, in every single English case where the parties have chosen a seat but not included an express choice of law clause for the main contract, the arbitration agreement has been held to be governed by the law of the seat. That's the short answer. The longer answer is that Chubb's general approach to the proper law issue is, we say, also wrong as a matter of principle. It treats an arbitration agreement as if it's like any other clause in the main contract, effectively indistinguishable in principle from the rest of them. So it says any choice of the law for the main contract should therefore be treated as a choice of law for the arbitration agreement as well. And we say the flaw with this is that arbitration agreements are not indistinguishable from any other provision in the main contract. They deal with a commercially distinct subject matter, namely the resolution of disputes if things go wrong in accordance with the rules and laws of an identified place or seat. And their distinct nature is reflected in a variety of ways, including the fact that, as is common ground in this situation, in this case, they may be governed by a different law than the main contract. In our submission, an arbitration agreement has, for reasons I'll explain, its own distinct gravitational centre, given its relationship with the curial law and the courts of the seat. And it makes sense, given that, for the parties' arbitration package to be governed by one law rather than two, and for that law to be the law of the seat. Now, there's been much reference by my learned friend to presumptions and things of that sort. We don't use that formulation. What we say is, what we're doing is effectively respecting the autonomy of the parties. The question is simply, what choice have they made by choosing a seat? If we're right that choice of seat is an implied choice of law, one gives effect to party autonomy by giving effect to that implied choice. We also say this will remain ordinarily the case, even if there is an express choice of law for the main contract. I stress that's not this case, but it's why we say the Court of Appeal was also right to conclude that even where there is an express choice for the main contract, the arbitration agreement will ordinarily governed by the law of the seat. Obviously, absolute rules aren't possible in this context, given it's ultimately a question of construction, and it's possible for an arbitration for a contract to specify otherwise. For reasons I'll come to, it should be and is a rare case. Thirdly, Chubb is also wrong to contend the court should decline. Lord Burrows.
Yes.
Yes, I'm not necessarily wanting a response now, but I would just like you to think, perhaps, unless you've got a response straight away, whether you would apply the same reasoning that you've applied to arbitration agreements to exclusive jurisdiction clauses. So in other words, you're saying, as I understand it, that a choice of seat for an arbitration agreement in an arbitration situation constitutes an implied choice, at least, of the choice of law for the arbitration agreement. And I was just wondering whether you'd make the same point about an exclusive jurisdiction clause. So if we have a contract that's governed by Russian law, but with an exclusive jurisdiction clause saying that the courts of England have the exclusive jurisdiction, does that affect the starting point for the working out of the choice of law for the main contract?
Lord, a short answer now, a longer answer to follow. We would say that there are similar points can be made in relation to a situation where there's an exclusive jurisdiction clause. There are additional points which apply in relation to an arbitration I'll deal with that at slightly greater length tomorrow, if I may.
Thank you.
Briefly noting the time, and if you'll permit me in a further minute, our third introductory point is we say Chubb is also wrong to contend that this court should decline to grant an anti-suit injunction on comity grounds. The Court of Appeal granted an anti-suit injunction to restrain Chubb from breaching a promise it had made, not because it was behaving unconscionably. And where a court is restraining a breach of contract, we say comity has little role to play. True role of comity, putting it another way, is to enforce contracts, whatever their proper law. A small point on terminology. When we say that Chubb is in breach of contract, that's obviously just shorthand for its breach of the equitable or quasi-obligation to arbitrate claims falling within the scope of the arbitration agreement. We obviously don't mean that Chubb, given the way it came into this, is actually a party to that agreement. But that doesn't affect the situation. Lord, I see the time. That would be a convenient moment.
Yes.
There.
Thank you very much indeed, Mr. Dicker. We'll sit again tomorrow morning at 10:30.